The presidency is seeking to recoup over 28 million rands in legal fees paid for former President Jacob Zuma by the state. The state attorney wants the former president to pay back all the monies paid to his legal representatives in respect to all legal costs incurred in his personal capacity. Advocate George Amukumamits says the state will not oppose the DA's application to also include interest.
Ultimately, we will not oppose the DA's claim that interest be paid. And obviously, had we embarked on the amendment process, this would simply have delayed the matter, and we dealt with it in the best way we thought possible. Now, in respect of our application, and if you have regard to what the first respondent says, the only conclusion we can arrive at is that our application is unopposed. And I say so specifically because at case lines 003-57, that is paragraph 122 of the answering affidavit, the first respondent says that I have not dealt with the allegations contained in the founding papers, and to the extent necessary, if I recall the precise words, he says, I deny them. So the first respondent does not comment on the account, the accuracy thereof, neither does he say anything about the long history set out in the founding affidavit. All the first respondent does is to raise legal defences, and in that regard we say those legal defences are ill-considered. They could and should have been raised in the review proceedings, and the horse has now bolted. You cannot raise those defences before this court today.
The Democratic Alliance wants the state to attach Zuma's Nkandla Homestead, failing which the state attorney must obtain a writ of execution or garnish order against the former president's pension benefit to recover the 28.9 million rands. Legal counsel for the DA says they want the interest to be added from the date of the demand for Zuma to pay back the legal fees.
The principle that is set out in Section 2A is that in respect of, not only in respect of liquidated debt, but also in respect of unliquidated debt, which in the process of adjudication become liquidated and due and payable, interest becomes payable. So interest is payable, in short, on a liquidated amount or liquidated debt which is due. The principles with respect don't need to be debated any further. They are sufficiently well established. And the applicants initially were minded to apply to amend the notice of motion to include a prayer for costs. They didn't do so on a twofold basis. The first and most significant of which appeared to be that for some reason this was not regarded as a debt. With great respect, that contention is entirely unsustainable. The court ordered repayment. That is the obligation. That is a debt as a result of the order or as a result of the repayment order. And with great respect, that's the end of the debate.
Adv Thabani Masuku pointed out that the Supreme Court of Appeal didn't find Zuma was in the wrong. However, the state received bad legal advice and acted on that advice, which has landed Zuma, the former president, in trouble.
Constitutional conduct, which was committed by them, is not being accounted for. There is no accounting at all by them. And yet, the very reason why we are in this position, why Mr. Zuma is in this position, is because of their unconstitutional conduct. Just identify in the judgment where it is found that Mr. Zuma acted unconstitutionally. There is none.
Former President Zuma's legal team has argued that a declaratory order wanting the former head of state would impoverish him and leave him in debt until death. The DA wants the state attorney to attach the Nkandla Homestead or attach his pension to recoup 28 million rands paid in legal fees for Zuma's personal capacity. But Zuma's legal team says he is not liable to pay anything. Samkela Masego, SABC News, Pretoria.